Part.1 here of the High Court. Did any of you, while you were with us at Griffith University...
William Griffith.
Aha! You know, Professor. Did everybody figure out who Griffith University is named after along the way? Some of you did. Very certainly did. So Griffith University is named after Sir Samuel Griffith, who was he was born in Wales. He emigrated to Queensland. He became a politician in Queensland. He was the Premier of Queensland a number of times. And he was also one of the first colonial leaders to really advocate for federation of the Australian colonies, and played a crucial role in the movement to federation. I could go on about that for a long time. Then when he retired from politics and he was appointed to the Queensland Supreme Court, and he was the Chief Justice of the Supreme Court of Queensland. This was all just leading up to the Federation of the Australian Colonies in 1901. And then, when the colonies federated and the Constitution was adopted, one of the things that the Constitution created was the High Court of Australia. So there was a constitutional court to go with the Federation. And for the first High Court of Australia that was appointed in 1903, there were 3 judges, and the first judge, the Chief Justice, was Sir Samuel Griffith. So he was appointed by the Governor General, by the federal government, from the Supreme Court of Queensland to be the first Chief Justice of Australia, and he was Chief Justice, I think, for about 20 years until he died. In those days, they died it was for life. It was until 1977 that the Constitution was amended to say that federal judges had to retire at the age of 70. So they couldn't be like the American ones. I don't know, if in Indonesia, is there a...
70 also.
70?
And 15 years.
Yeah. So we're very proud to bring people here and say, here we are, Griffith University, there's Sir Samuel Griffith, the first Chief Justice of Australia, of those first 3 judges. And Dinesh might explain the other 2 judges, but the key thing about them was that they were very much not just judges, they were all former politicians. In fact, I think Edward Barton had never been a judge. He might have been, I can't remember, but they were all colonial politicians who played a big role in the federation process. So they were very politically active, and they had a very strong views about how the federation was meant to work, what the constitutional deal was between the colonies to create the federation. So it made for quite an interesting High Court, very policy-oriented High Court. But I'll hand back to Dinesh. He can explain the other 2 and take over from there.
Thanks, AJ. The other 2 persons that are in this courtroom are our first Prime Minister in the smaller frame, that's Mr. Edmund Barton. He was the Prime Minister from 1901 when Australia federated till 1903. He saw passage of a number of enabling legislations for the new Commonwealth, and that was the flurry of work in the first 2 years. And after that, in 1903, the High Court, the Judiciary Act was enacted, and also the High Court Procedures Act was enacted as well, which gave the instrument for High Court to operate. So he stepped down from his role as the Prime Minister and became one of the justices, only to make sure that the dry bone document of our Constitution that did not have any life or any spirit in it was embedded in it. When this document was written, it was regarded as the dry bone document, and these people, having been involved in the Constitutional Convention around the country for a 10-year period, they wanted to make sure that this document survives for centuries to come. And along with the journey came Richard O'Connor, who was also instrumental in helping draft the Constitution, to frame it in the way they wanted. And he also stepped down from his role as the leader of government in the Senate, and he became a justice, and they went on to be the justices, the first 3 justices, for almost 19 years, at which time Edmund Barton fell ill and passed away, and soon after our Chief Justice also passed away, which meant then there was a new set of people that came through as justices. So these are the 3 justices that led the way, and 123 years later, here we are. In most courtrooms, you see the coat of arms. In this courtroom, they decided not to do that because it is the pinnacle of our judicial system, the highest court in the land, and therefore we don't have a coat of arms. But in its place, they decided to take the information from the shield of the coat of arms. So when you look at the Australian coat of arms, you've got the kangaroo and the emu holding up the shield. The information from the shield is in this tapestry. So the tapestry is made of merino wool, made by a company in Victoria, Victorian tapestry firm, and they put together what is regarded as the birth certificate of Australia. So birth as in the 6 colonies coming together, forming a nation and giving birth to the star. The star is called the Federation Star. It has 7 points, 1 point for each of the new states, and the 7th for the Commonwealth of Australia and its territory. So in this picture, in this tapestry, there's no ACT, there's no Northern Territory. We fall under the Commonwealth. Although we are autonomous, we run our own governments, but we also are under the umbrella of the Commonwealth. So the 6 emblems are the St. George Cross, the red one, is New South Wales. They were the most populous at the time, so they got the first place. The second was Victoria, and then the third, Queensland. Fourth on the bottom row is South Australia with the piping shrike, the swan for Western Australia, and the lion for our island state of Tasmania. So these were the 6 colonies that came together. Any questions before we start here?
There are 2 questions. First, why you name it High Court rather than Supreme Court?
So in our constitution, I'll answer that one first. So in our constitution, our proper name is the Federal Supreme Court of Australia. That's in the constitution. But so as to not confuse everyone, because all the states and territories have their own Supreme Court, they decided at the Adelaide Convention to call it the High Court of Australia. So in the constitution, our proper name is the Supreme Court of Australia. The Federal Supreme Court of Australia is the proper title. But for operational purposes, we call it the High Court, so as to distinguish it from the 2 bodies.
Yeah.
And your second question?
Second question is about the number of justices. Why 7? Mostly 9.
Yes. Our population doesn't demand the 9 at the moment. Originally 3. We went from 3 to 5. Then there was the war, where we went back to 3, and then went to 5, and very quickly to 7. But if you see the bench of the High Court, there are 9 microphones. So the designers envisaged that someday in the future, maybe in 10 years, 20 years, 50 years, when our population is big enough to warrant that number, the Parliament can determine that and maybe have 9. So the designers that did this building 45 years ago saw that maybe one day we will have 9 justices. So therefore there are 9 microphones on the bench, but only 7 in use.
Yeah.
Yep.
What specific cases that can be bring on a trial in a High Court?
Sorry, I didn't get that.
What specific cases can be bring on a trial to the High Court, compared to the Supreme Court or maybe District Court in federal?
So there's no trial per se. Cases come to the High Court with a point of law question, how the law was interpreted in the lower courts. So that would be an appeal, whether some form of miscarriage of justice happened, or if the case itself has become of national interest or national significance. One of the cases that came recently was about domestic violence against women. So each state has got a somewhat different interpretation of domestic violence against women. So when a case came here, the High Court allowed that special leave to come through, only to give direction to the entire country that when it comes to matters with domestic violence against women, this is the kind of the benchmark we need to look at cases. So that would be an appeal case. But in terms of the this courtroom, cases coming against the Constitution, it can come from anybody, any person that believes a government has made rules that are unconstitutional or Any business can say that, you know, the government has made rules that are unconstitutional, therefore our business is on the slide or something like that.
Second question.
Yep.
Thank you. What authority that Chief Justice holds different to other justices?
He doesn't hold any other authority other than he is just an equal justice when it comes to the High Court. But our Chief Justice is also the representative of the Governor General. So where a Governor General can't get to, normally they would send the Chief Justice. So for example, our last session, the opening of the current Parliament, Governor General couldn't go because there were some issues with the finality of the members in Parliament, and so the Chief Justice went there and officiated in the Parliament in lieu of the Governor General. So there are some ceremonial roles that our Chief Justice has, but in terms of when they are operating at the High Court, they are all equal. 7 judgments are handed down, no more important than the other. Yep.
My question is that can a ruling of the High Court be challenged again if there's a new evidence or new circumstances found in the future?
Yes, exactly. So everything that we do is recorded in the precedent documents, so our Commonwealth Law Report, which is all lined up at the back there. So every decision the High Court has made is recorded, but then in the future our life changes, so the court can look at some decisions made previously and change it to say perhaps in 1963 this is how we ruled on a particular matter, but then wind the clock forward 50 years, we can revisit that case and say, no, perhaps it was the right decision at the time, but given our lifestyle has changed and all the surrounding environment has changed, we perhaps need to look at it again. And in new light, in today's circumstances, that was not perhaps the right decision. We won't make the same decision again, and the new decision is this. And that gets recorded in the precedent document again in the Commonwealth Law Report. And then going forward, we will look at any similar cases in that view.
Yeah.
Sorry, we'll take one more question. Yeah.
Are these 7 justices divided to certain chamber based on their concern, or all of these 7 justices examine each cases?
Sorry, I didn't
Yeah,
understand.
all these 7
Seven,
judges divided to the certain chamber, like tribunal or private chamber or
No.
civil chamber.
No, they all are just the justices of the High Court.
Oh,
Yeah,
all
equal
7.
responsibility. Yep.
Thank you.
Any other questions? Yep.
Very last one.
Okay.
Does the final decision of the High Court
menarik.
final and binding to
Yeah.
every citizen and everyone?
Yeah, it is a final and binding decision. So everybody has to sort of move on, live with it. Whether it's a decision handed down by this court or the appeals court,
Doesn't
it
make
is final, and we move on. Yeah, we don't have that opportunity to take the case to England anymore. That review by the Privy Council has ended when we enacted the Australia Act. Yep. All right, we
Aduh.